This is Joel. Thank you for inviting me to speak to your ETA class a couple of weeks ago. And thank you for sending me their additional questions after we gave our presentation. So I've got all the questions in front of me. It's probably going to skip a few here and there. See if I can just give you some off-the-cuff kind of initial reactions and answers. First question, are there more legal disputes in mergers and acquisitions during the pandemic than before? No, I don't. At least I'm not seeing that in my practice. In fact, what I'm seeing is not more disputes, but more transactions. In the current economic environment, is it easier to start a personal company with the help of the internet? I don't think it's any easier. It's always been fairly easy to use the internet to start a company, a personal services company. So I don't think that the economic environment really has caused an increase, but I think what's happened is that more people are open to the idea of starting their own personal services company, and so the internet's there to help them. What is the best career advice you've ever received? I think it's, I don't know if it's really career advice, it's perhaps more life advice, but the best advice I've received is the only thing that time does is pass, and I've always taken that as a kind of an inspirational quote to tell me that I should be moving forward. I should be doing something rather than just waiting for something to happen. What are the most common law issues to face when acquiring a small business? I think the buyer has to look out for a number of things. You want to make sure that you're actually getting title or ownership of the assets that you think you're buying. You want to make sure that the valuation is good. You want to make sure that you're getting promises about the assets in the business to give you comfort that it's going to be what it's represented to be. What are some similarities and differences in legal processes for a startup versus an acquisition of an established company? Well, they're wildly different, frankly. If you're just starting a small company, the legal issues are relatively simple. If you're trying to bring in investors in exchange for equity, that becomes more complicated. But when you're buying a company, you could have those same type of issues if I know Ram does a lot of equity finance or investor financed acquisitions. So you're dealing with those regulated type of transactions anyway. What motivated you to choose M&A law? What motivated me was I thought being a lawyer sounded interesting. It looked interesting, but I didn't want to go to court. And then I discovered that I could do transactions, and that's really what helped me gravitate, toward that. What are the most common mistakes that buyers do when buying a small business? There are perhaps some details that they don't think are that important, but I think are very important. So, for example, you're going to find that when you do an asset purchase agreement, there's going to be a lot of legal language, and that legal language is there for a purpose, and it means something. Some of the things that are most important are the representations and warranties. Those are the promises that the seller is making to you about the business and the assets. They're very important. Also, it may not seem that important, but there are typically going to be a number of exhibits and schedules to the contract. Those are very important as well because they make up a very important part of the contract. So, for example, if you don't really care about the detail of the list of assets that you're purchasing, then there's a possibility that after the closing, the seller may claim that you didn't include a particular asset in the list, and so you don't own it. So those lists, those exhibits, those schedules, they are very important and need to pay attention to those. What is the best time when you're acquiring a business to engage an attorney? I think that the sooner the better. If you wait too long, you could end up losing a lot of your rights and protection. You also, if you wait too long, you could end up giving the lawyer such a short time frame in which to prepare for and do the closing that it's going to be very difficult. So I'm always of the opinion that sooner is better than later. Most attorneys like myself will tell you if you're too soon and perhaps when to come back. But certainly you want to have an attorney before you sign anything that's a legal document. What's the average multiple for the business valuation to EBITDA in deals that you have supported? Honestly, I don't know. I kind of rely on my clients. I'm not a finance person. I'm not a CPA, so I rely on my clients and I rely on their other team members like their CPA to help us determine whether the valuation is fair. How does law knowledge help in mergers and acquisitions? We want to make sure that you're protected and that you're getting what you think you're buying. And so we need to make sure that the contracts are clear and that we're going through the process appropriately to get title to the assets transferred to you. What are common obstacles you see in small business startups when they're creating their first business? I think, again, whether it's either starting up a business or acquiring a business, one of the biggest obstacles I see is making sure that you have enough working capital after you close, whether it's a startup business or if you've purchased a business and you've closed on the business. Do you have enough working capital to sustain yourself until you can reestablish cash flow or establish cash flow? What are the most important issues that lawyers focus on in the due diligence process of equity transactions? When you're acquiring a business during the due diligence process, there are a few things that you want to make sure that you understand. One of them is whether there are any liens on the business or the assets of the business. And if there are, can those liens be satisfied at closing? You're going to do your financial due diligence and make sure that, again, that you've got enough cash flow after closing to service the debt that you're going to take on. That's a big one. What's the most advantage of buying a small business? One of the advantages is that you are in control, that you're running the business, and that tends to create some freedom. You work for yourself, and I think there's a lot of value, intangible value in that. What is the most commonly overlooked part of a contract that is important for small business buyers to be aware of? I think that the two that I've already talked about, the list of assets that you're purchasing and also the representations and warranties are very important. One of the things that I've been seeing fairly often, which surprises me a little bit, is a buyer who tries to buy accounts receivables that were accrued prior to closing without taking on the payables that were accrued or incurred prior to closing. To me, receivables and payables should match up. Otherwise, the seller is going to be left with payables but no cash or little cash to pay those payables. So if the buyer thinks that they need to acquire accounts receivables in order to maintain cash flow and have working capital after closing, they also need to be ready to take on the pre-closing accounts payables so that they match up. Otherwise, I don't think that's a very fair deal. And I've seen, in representing sellers recently, I've seen a lot of buyers who have come out of the box and said, we're buying the accounts receivable so that we have cash flow immediately after closing, but they're not willing to take on the payables. I don't think that's really fair. What's your advice in deciding who will be the best lawyer to choose as a partner in the ETA journey? Well, again, we talked about this a little bit during our class presentation, but I think that you really need to have somebody who has experience in small business M&A work. I don't really think that trial attorneys or people who focus on lawyers who focus on trials and litigation are necessarily going to be your first choice. I think you want to make sure that you find somebody who's done a number of transactions and perhaps transactions in your particular industry, and also transactions that involve creative financing arrangements or at least work with commercial lenders and SBA lenders. And that's easy to find out. I'm going to skip all the international transactions questions because I don't really do any of that. And I'm skipping all the questions that are specifically addressed to ROM. What do I want to share most about my book? Well, I think that what I hope people, where I hope they find the value is that it explains a process that many people, especially those who are doing it for the first time, aren't aware of. I want the reader to understand that the process of buying a small business is pretty complicated and has a lot of moving parts. And so I want to reduce the surprise. I want to kind of demystify the process for people so that they understand what they're doing, what they're getting into, what questions they need to ask, and even how much time it might take to go from finding a target for acquisition to closing the transaction. I do commercial real estate, but I think I'm going to skip those. I'm going to skip these private equity questions. I think they're more for ROM. What's the most common mistake that people do while acquiring a business without a lawyer? Well, I think the most common mistake is that they think they are the lawyer. They think that they're comfortable enough with the law. I've had clients who haven't used a lawyer for acquisitions or contract work who have signed contracts without fully understanding. They thought they understood what the contract meant, but the contract either had language in it that meant something else or was missing language that should have been in the contract. In fact, perhaps would be customary to be in the contract, so they end up with a bad deal. I just don't think it's a good idea to do a transaction without a lawyer. What are the best ways to discern a good lawyer from an average one? I don't know. I mean, I that's a tough one for me because most of my colleagues are very good lawyers. And so, again, I think it's more not so much a good versus average lawyer, but a lawyer who's comfortable doing these types of transactions, a lawyer who has experience doing these transactions, who's had a lot of issues pop up and come up with ways to resolve them, and knows what kind of the customary approach is and the reasonable approach is to resolving a lot of legal issues involved in transactions. How did I decide to write my book? Here's the deal. Well, I kind of always wanted to write a book. I had read some other books about how to market my law practice that suggested that writing a book might be a good way to establish yourself as an expert in this particular area. When it came down to it, I wanted to make sure I had a resource that my clients and potential clients could use and would be valuable to them. When I was thinking about the topic of the book, I did some research and looked at about 10 years worth of projects that I had done to identify where kind of the lion's share of my practice was. And I realized that at the time, if I didn't really know it, I had done a tremendous amount of small business M&A work. I also did some research on Amazon to see how many other books were out there written by lawyers on small business M&A, and there weren't very many. So I felt like I had a very good synergy between my target audience, the purpose of my book, the topic of my book, and the demand or the need for my book. So that's kind of in a nutshell how I came up with all that. What terms of commercial law give small businesses advantages over bigger competitors? What kind of provisions might I try and put into a contract to maybe shift the balance closer to the small business when they're dealing with a larger business? I would say that one of the most significant provisions to try and make that shift is what I call an attorney fee shifting provision. In the American system, if you have a dispute, everybody pays for their own legal fees, even if you win. So if somebody breaches a contract and you sue them and you win, you still have to pay your lawyer for your legal fees. But with an attorney fee shifting provision, that provision will say that whoever wins, that the loser will have to pay the winner for the winner's attorney's fees. And what that does is that helps a bigger company or a bigger competitor reevaluate the risk assessment of a dispute because they now have to factor in not just the fact that they might lose the amount of damages that you're suing for, but on top of that, they also may have to pay your legal fees. And so that tends to give the smaller business a little bit more leverage and bring people back more to the center. What career advice would I give to students who are interested in entrepreneurship through acquisition? I would say that you just should be aware of your own limitations to some degree. In my book, I talk a little bit about, at the very beginning of the book, about people who are trying to do an acquisition in an industry that they don't know anything about. For example, earlier this year, I helped close a transaction with somebody who was buying a gutter installation and replacement company. And so one of my questions was, do you have any experience in the construction industry and maybe even in the gutter industry? I think it's important. It can be, you can learn new industries, but trying to learn them at the same time that you're trying to learn how to operate a company post-closing is pretty difficult. So I would say that, that's one piece of advice that I give a lot of clients is make your acquisitions within industries that you know something about or that you have some experience with. How did I get my first job? My first job was at a local family-owned pizza restaurant when I was 16 making pizzas. But I don't think that's what the question's asking. I think the question is asking perhaps how did I get my first small business M&A transaction? And at the time, I worked for a very large law firm, and I was a young attorney. And so a transaction came in that was worth, I think the purchase price was between $8 and $10 million. And this is about 25 years ago. The partner that I worked for came to me and said, you've got enough experience now that I'm going to assign you this particular transaction. You're going to lead the team. You're going to lead the transaction. You're going to be the primary contact with the client. and I'm going to be in the background to coach you and help you and train you. That's how I got my first small business M&A transaction. Once I was able to kind of prove myself through that, I worked for a big law firm for another probably 8 years and was assigned many other transactions. And then when I started my own solo practice, I was able to advertise or market my expertise and continue to get more transactions. The book helped a lot too. What's the difference among law issues of acquiring companies in different industries and different development phases? Well, in different industries, I think you just need to be aware of how those particular industries are regulated. So, for example, I do healthcare acquisitions like small medical practices, dental practices, and those have certain types of regulations involved, and so we just need to be aware of those and make sure we address them in the deal documents. Other industries, I've helped people acquire and sell restaurants that offer beer and wine, and so we have an alcoholic beverages license that goes with that. So some industries are going to have some additional regulations involved, and we just need to make sure that we address those in the deal documents and that everybody knows what we're doing and how we're doing it. What are some of the covenants that I strongly recommend to be included in the agreements at the time of purchase? From a covenant perspective, a seller promises that they're going to make are involved in the representations and warranties about the business, the assets, the operation of the business. Certainly, it's very common that you'll want a seller, and not just the seller, but the principals of the seller, to sign a non-compete and a non-solicitation agreement. During my time working with mergers, acquisitions, and startups, what led the businesses to succeed and what led them to fail from a lawyer's perspective? I think that one of the most significant things I've seen is not having enough working capital or cash flow immediately after closing. That's a really big issue because if you can't service debt, you can't make payroll, you can't buy inventory, things like that after closing, that's an issue. In what industry do I specialize and what's the deal volume attractive for you? I have a broad spectrum of industries that I work in, but certainly construction industry, retail and restaurants. I've done healthcare. I've done a number of dental practices, medical practices. I've done some tech industry businesses like software companies and e-commerce companies as well. Deal volume that's attractive to me, I'll take everything I can get, frankly. But I'm typically, in the last couple of years, I haven't even looked, but maybe I'm closing 20 transactions a year on average, I'd say, and that keeps me quite busy. Have I experienced any professional ethical challenges as a lawyer? Not really. I have had some experiences where I have felt uncomfortable with a potential client and I've declined that representation and then later found out that they were doing some unethical things. So I was happy that I declined. But no, I don't really feel like I've had any ethical challenges. There's some routine ethical things. I mean, I did a healthcare transaction that closed earlier this year where I was representing the seller and I had represented the buyer in some real estate transactions many years ago. And so it was pretty routine. We just needed to do have everybody waive the potential conflict of interest, and everybody was fine with that. The buyer did have his own attorney, so it wasn't as if I was declining to be his attorney for the transaction. Which one is better, hiring a lawyer or adopting the legal agency service? I'm not really sure what the legal agency service is, so I'm going to say hiring a lawyer is better. How does a first-time small business buyer choose the right lawyer? We talked about that in class a little bit. I think it's worthwhile to do some preliminary research and then to actually interview a handful of lawyers to see who might be the best fit, not only from an expertise perspective, a practice focus perspective, but also from a personality perspective and the perspective of how that lawyer approaches transactions. Are they very combative? Are they very adversarial? Is that what you want? It may be. I mean, in some instances, that's a good thing to have, but in other instances, you might want somebody who's more of a deal builder and somebody who is going to take a more kind of middle of the road approach to negotiation and reasonableness and things like that. And, frankly, in these transactions, a lot of things are customary, and reasonable. And so negotiations go pretty smoothly when everybody understands what those customary and reasonable things are. What's common fine print that a buyer has to read on documents? Read it all. I mean, seriously, read it all. Even what people call the boilerplate can be significant, because in those miscellaneous sections or general provisions, that's what they're typically called, that's where you might find your attorney fee shifting provision, and that's very important. I would say there is no fine print. It's all, I guess you could say it's all fine print, but I would read it all. I mean, these are important deals, and they have a lot of implications to them and risks. It's important for a student studying finance to take certified law exams and expand knowledge in the field of corporate laws. I would say it's probably not important I don't even know what certified law exams are, but I don't know that you have to go that far. If you're going to hire a lawyer to help you with this, I think it's good to have a familiarity with the laws that you're dealing with, and more so what the legal documents mean, what the language in the legal documents mean. But you can learn that by interacting with your lawyer and making sure you read and ask the right questions. How much about an industry should a potential investor know before investing in it? I'd say quite a bit, frankly. I've seen people who are, perhaps have a lot of hubris about the fact that they were successful in one industry, and I'll give you an example from years ago where I had a gentleman who was an engineer. I think he was in the aeronautics or aerospace industry, and he decided to take his severance money. He bought a franchise for a children's furniture store, and he didn't know anything about retail. He didn't know anything about how the furniture store would work. He didn't know anything about being a franchisee and about being in a franchise system. Man, I don't think he lasted a year. He fought with the franchisor constantly. He didn't understand the concept of cash flow and how the business, just operated in general. And it was a real struggle for him, real struggle. So I think you should know about the industry before you get involved in it. Have you ever met problems explaining things to your clients? Yeah, absolutely. I mean, it's being a lawyer is like speaking a foreign language. And so many times what I'm doing is translating or interpreting. And what I do to solve it is I wrote a book, for one. I've actually used that book given it to clients as a reference and told them, if you have a question about something, maybe look in the table of contents first, see if you can get an answer there. But definitely call me, and we just communicate a lot, and I try and ask a lot of questions and understand where their perhaps difficulty is in understanding something, and we just work from there. How different of a process is, if any, selling a business and selling a real estate property? I will tell you that selling a piece of real estate is a much simpler process than selling a business. There aren't as many moving parts, especially when you're the seller. You're essentially just signing a purchase agreement, waiting for the buyer to do their due diligence and get their financing, and then you're delivering a deed and maybe a couple of other documents at closing, some affidavits and some real simple closing documents, and that's the end of it. Selling a business is a little bit more complicated and takes a little bit more time, but in some ways similar, because you're waiting for the buyer to do their due diligence, waiting for them to get their financing. There are, I think, more legal documents involved in selling a business than there are in selling real estate. And typically you're making more promises, representations, and warranties about the business and the assets that you're selling. When you're selling real estate, generally there are very few representations and warranties that are made. And those are some of the differences. What's a contractual condition that you never have to agree to when you're buying a business? I'm not sure exactly what that question means, but I think perhaps the way I would interpret it is, sometimes do sellers ask for unreasonable things? And I would say yes. Maybe we could flip it a little bit. They may want the buyer to assume some liabilities, but not be willing to give up some, accounts receivables or something like that to help the buyer have cash flow and capital to cover those liabilities. I don't know if that's a great example, but that's perhaps one of them. In my experiences, what was a small slip up in legal documents that caused great complication to a buyer? Well, I honestly can't recall anything. I mean, we've caught things in transactions, not necessarily in the legal documents, but I gave an example during class about A seller had made some representations and warranties in the contracts in the purchase agreement about inventory and about the value of inventory, but then was unable to give us a list of the inventory so we could cross-reference or cross-check it against the value and against what we were buying. We never closed that deal because the seller could never give us the information or comfort that we needed. So we never got to the slip up because we were, I guess, smart enough to focus on it and ask about it before we signed anything. What are the most important items to pay attention to in a contract for purchasing a business? Again, I think it's important to focus on what you're buying, making sure it's very clear what you're buying, what the assets are. I think you need to focus on how the purchase price is going to be paid. Also focus on any contingencies to closing. So if you need to get certain things, like you need to get a lease transferred or get a new lease, or you need to get financing, or you need to get investment injection or something like that. Those contingencies all need to be in the contract. The representations and warranties, the promises that the seller is making are very important. The indemnification provision is important. Also, I think one of the things that people don't really think too much about is when you are getting an indemnification from a seller, if you're getting that indemnification only from the seller's entity, like corporation or LLC, you have to remember that after closing, that entity is really not going to have any money. And so you need to think about getting an indemnification not only from the entity, but also from the owner, the individual owner or owners as well, because they're the ones who are going to end up having the resources to back up the indemnification provision. What is the motivation or objective of your career trajectory? I'm not sure exactly. That's kind of a deep question. I'm not really sure how to answer that. I have never had like a 5-year or a 10-year plan for my career trajectory. I think my motivation's always been survival to some degree, making sure that I can provide a comfortable living and opportunities for my family has always been my primary motivation. I'm on to column 3. I know this has taken a while, but I hope this is valuable to some degree. How can lawyers help companies design a reasonable and effective cooperation plan and then affect the commercial value of the overall project? I think perhaps what that question is asking is about post-closing transition or post-closing cooperation. One of the things I advise a lot of my sellers against is staying in the business for too long after closing. For example, a couple of years ago, I did a transaction where my seller wanted to stay in the business for 6 years after closing as an employee for part of that time and then a consultant for part of that time. That's a bad idea, I think, because psychologically it's going to create a lot of tension, a lot of problems. I've seen that happen in a number of transactions where the seller stays too long because the seller has always done things a particular way, and when they see the buyer changing things up, it creates a lot of tension and can create some disputes, and I've had to negotiate some earlier exits for the seller because of that. How did I decide where to establish my company? It's a good question. I decided I wanted to practice law in Virginia. I grew up in the Washington, D.C. area. I went to undergraduate out west, and when I came back to the Washington, D.C. area after graduation, it was difficult to find a job for a couple of reasons. But one is that a lot of employers that I interviewed with hadn't hired anybody from my university before, so they didn't have any experience with anybody from my university, any graduates from my university. So when I decided to go to law school, I decided that I wanted to be in the Mid-Atlantic. I went to law school in Virginia. My law license is in Virginia, so it's not easy to go to another state at this point. Any interesting law cases to share when acquiring a business? I don't do any litigations, so I don't really have any lawsuits to talk about. And fortunately, as far as I know, I don't recall that any transaction I've worked on. I can recall one transaction. So let's talk about that. One quick transaction many, many years ago when I was at the big law firm, I represented the sellers. And the buyer had a commercial loan for part of the purchase price and then asked the sellers to do some seller financing for a fairly significant portion of the purchase price. The commercial lender required that the sellers subordinate their promissory notes to the commercial loan. In other words, the lender always is going to get paid first. And we're able to negotiate a carve out to allow the sellers to get paid their post-closing salaries and consulting fees. But other than that, they weren't going to get paid under the promissory notes until the commercial loan had been either refinanced or paid off. So what happened was the buyer defaulted on all of the debt, on the commercial debt and on the seller financing notes as well. And so the sellers sued the buyer, but because they were in a second position, there really wasn't any money there for them to get, and they walked away very unhappy. Their position, though, wasn't really any less common than any position that a seller is going to take when there's a commercial loan in place in a first position. So if you're a seller and you're going to be in second position, you just need to understand that there is a risk that you're taking. Lawyers can be expensive. What are some of the ways to optimize the cost? And without making one side, I assume that means either the client or the lawyer, feel that it's not actually a beneficial engagement. Yeah, lawyers can be expensive, but we're not as expensive as the brokers, for one. I like to point out that the broker's commission is typically multiples of my fee. You just need to understand what kind of value we're adding to the transaction. We're risk management. We're risk protection. We're, in a sense, sort of like an insurance. We don't guarantee the work, but we are there to help you minimize risk. Ways to optimize cost, I don't know. I mean, sometimes I hear an approach of, well, if I draft the letter of intent first and then you have you look at it, or if I draft the asset purchase agreement first and have you look at it, is that going to save me money? In my experience, it generally doesn't save you a lot of money. I say you just find the lawyer that you're comfortable with, that the fees, the fee arrangement that you're comfortable with, and go from there. And then just not worry. It's just a cost of doing business. How can I find out about problems in the business, such as possible intellectual property lawsuits after acquisition? Well, hopefully you're finding out about those things prior to acquisition. You want to engage people to help you to do UCC lien searches, background searches on the company and on the individuals about, to determine whether they've been the subject to any lawsuits. I did an acquisition years ago that we ended up not closing, but when we did a personal background check on the principals of the seller, we found out that several of them had been charged with fraud, and they had pled guilty and worked a plea arrangement out with the prosecutors. And that was kind of a red flag to us. How many people in my team? 2. There's me, and my wife handles all of the financial aspects of my law practice and the marketing as well. I'm lean, and that's why my fees tend to be lower than a larger law firm. Let's see, I'm skipping some of these about investments and equity and things like that. What does the general process look like when you're helping someone purchase a small business? There are probably 5 stages that you could think about. One is target identification. So that's your research, trying to find the right target. Once you've found the right target, perhaps letter of intent negotiation and signature. Once the letter of intent has been signed, then you're into the due diligence period. And as part of the due diligence period, you're also working on your financing, whether it's equity financing, search fund financing, or commercial lender financing, or seller financing, or a combination of all those things. Once you're through that due diligence period, and then you're into the purchase agreement negotiation phase. Once the purchase agreement's been negotiated, then you're in the closing preparation. All the ancillary documents are going to be drafted, and you're going to go to closing. And then the last phase is really post-closing transition, and then, going from there. So in a nutshell, that's what it looks like. My book has a lot more details about that, those different stages. How do you find good partners? Is it a good idea to take friends as partners? That's a great question. And I think that, a lot of times we hear that we should never have friends and family as partners. But frankly, if I didn't have friends as clients, I'm not sure that I'd have a lot of clients. but especially when I began my practice. So I think it's not a good idea or a bad idea. I think what is a good idea is to make sure that whoever you bring in, whether it's a friend or a family member, that you treat them as if it's an arm's length transaction, and you make sure that you have the appropriate legal documents in place as if they weren't a friend or a family member. And that's reasonable. And if they balk at that, then that might be a red flag. When being involved in multiple business activities, what are suggestions that you have for time management? That's a great question. What I've found that helps me, at least recently, is to be very diligent about blocking time off on my calendar and then trying to respect that block of time. Right now I'm working on, I think I have 7 or 8 transactions that I'm working on, and I blocked off 2 hours today to work on one transaction, another hour today to work on another transaction. And so when that 2 hours of time block was up for the one transaction, I just, whatever I'm doing, unless it's urgent, I will drop it and transition to the other transaction. I don't know that that's a great tip, but that's what's been helping me quite a bit recently. Do you have any advice for a college student looking to acquire their own business? I think that again, you just need to be careful about how much bootstrapping you're going to do from a financial perspective. If you're going to take on a lot of debt, if you try and get investors, plus maybe you're going to get a commercial loan, and then you're going to also ask the seller to finance some of the purchase price as well. That's bootstrapping, and the more bootstrapping you do, the more risk you're taking on that you're not going to be able to service the debt. And so I think just be conservative perhaps on your first transaction to learn the ropes and see how it goes, and make sure you don't bite off more that you can chew. Should people who do M&A know at least a little bit about the law, even if they have an attorney? I think what they ought to know about is they ought to be able to understand the basic principles and legal concepts that are in the legal documents that they're going to be asked to sign. You should be able to understand what's in the purchase agreement and why it's there. And the lawyer can help you with that, certainly. I spend a lot of time doing that with my clients from an educational perspective. If I were to pinpoint the most important idea in the book, what would it be? Hire a lawyer who knows how to do small business M&A transactions. Can you share with us some tips to acquire a business? Again, just some of the ones I've already covered. Make sure you know a little bit about the industry, that you're comfortable in the industry. There's a great story at the beginning of my book where I asked this question, do you like dogs? Where I had an individual who had spent his whole career in video production industry and was thinking about acquiring a large dog grooming business with multiple locations. And my question was, do you like dogs? And he didn't really understand at first why I asked that question or why it was important, but certainly, it helped him make a decision about whether to buy or not. What does wage, payment, hourly rate look like for having a good lawyer by your side? I don't know, frankly. It's going to vary based on geographic location, size of the law firm, experience of the attorney, notoriety of the attorney perhaps as well. I know that in some bigger cities, you're going to pay lawyers $600 an hour or more. You're going to pay lawyers who are solo practitioners less than that. But again, it's going to depend on where they're located geographically. You're going to pay somebody in New York City, Chicago, Los Angeles a lot more than you're going to pay somebody who is in in Virginia Beach, for example. Which components of a merger acquisition typically face the greatest scrutiny? And how would you say your approach to negotiating acquisition terms differs from everyone else? So I'm going to go with the second part of this question. I don't know that I differ from everyone else, but I think that one part of my approach is that I always look at the deal from the perspective that both the buyer and the seller want to close the deal. And so I don't want to stand in the way of that objective. I will try and work with opposing counsel in a way that kind of more of a middle of the road negotiation, where all of us who are involved in these types of transactions are pretty well aware of what's reasonable and customary. And so my negotiations are going to work us toward that reasonable and customary approach. I certainly have had transactions where the attorneys on the other side have been more difficult in negotiations, and I can go toe-to-toe with them as well. One of the approaches that I have is to be a filter for my clients so that I'm going to help them prioritize. I'm going to help them identify the legal issues and risks, but also prioritize them and suggest resolutions, and also suggest things that maybe we just let go because they don't present that much risk. What's the biggest challenge you've been through during your career, and what is the takeaway from this lesson? My answer has nothing to do with small business M&A work, but the biggest challenge I've had is investing about 12 years of my career at a large law firm, but not being promoted to the partnership at the law firm for various reasons. That was kind of that moved my cheese, I guess we might say. The biggest takeaway is that I learned that I could start my own practice, provide very valuable service, create a good reputation, also have a lot more freedom to do what I do and to try what I want to try, and enjoy my practice much more. The other thing I learned is that lawyers who are solo practitioners or small firm practitioners tend to be a lot more supportive of each other in their community than perhaps lawyers at the larger law firms, and that's been very refreshing. It was surprising at first, frankly. All right, thanks. That was a long time, but that was kind of the lightning round. I hope you can find something valuable in that. And I'm always available. You can email me, joel@jalawoffice.com. You can go to my website, which is just my last name, ankneylaw.com. I have a blog there that answers questions as well. You can always submit questions to me that I'll answer on my blog as well. I love to do that. I also have a YouTube channel where I give video responses to a lot of the topics that are on my blog and questions that I receive. You can follow me on LinkedIn if you want as well. Thank you again, Mark, for having me as part of the class. And